Alrighty, so moving right along, our next speaker is Charles Phipps. Charles is an attorney here in Columbia who specializes in immigration law, and he's going to talk to you about representing non-citizen clients.
Good afternoon. How is everybody?
Good.
Okay, good. What I talk to you about is something that you're not going to deal with every day, I presume. But when you do have to deal with it, it's important. And so I want you to remember enough from this presentation that when you see it, you can be like, I know I heard about this somewhere. Where was that? And you can dig this up and find my phone number and give me a call. All right? I'm going to give you a lot of information. Immigration law is kind of like tax law. If somebody was explaining tax law to me, I would glaze over in 5 minutes and wouldn't retain it. And unfortunately, immigration law has a lot of complexity to it. It's not as obvious as maybe you would think it is. And so I'm going to give you some of that detail, but I don't really expect you to retain it. I hope I give you enough resources that you can look things up if you need to, and always that you can call me. Has anybody here ever had, to date, any experience with foreign-born clients in a criminal context? Oh, look at that. Okay. What, like, anybody willing to share, like, generally what type of case? Like, what kind of situation? Yeah.
Trying to get a green card, charged with a whole bunch of motor vehicles.
Oh, in process of getting a green card. Okay.
And we're trying to figure out what to plead them to.
Oh, I can help.
I have two that have entered illegally, both of them. One of them has drug charge,
Okay.
and then the other one was domestic violence.
Okay. Both bad. Yeah.
Violence, drugs, criminal sexual conduct with minors.
Oh, okay.
All of them.
I mean, you're public defenders, right? It's not going to be speeding. I know that. Uh-huh.
CSU is a minor.
Yeah.
Domestic violence, drug-related cases.
Okay. All right. We're going to touch on all of that. Uh-huh.
My drug charge guy, he already has an ICE hold on him.
Yep.
And he was already supposed to leave this country for something else, but never did.
Yeah, he's in a lot of trouble. Okay. So that's great. Sometimes I have people with like zero experience like that, and so that's great. So those of you who've dealt with this, chime up as we go along if there's questions that are raised in this. I like to start just posing two hypotheticals that we'll circle back around to at the end, and I'm throwing out a lot of information here, but I promise I will define and explain all of this. And so I'm right now just giving you these two to kind of put in your head, and then we'll touch on it throughout the presentation. So hypothetical one is lawful permanent resident Margaret. And of course, these aren't totally made up. Believe it or not, this is really kind of touching on sort of a real case. Somebody comes to deliver to her store, and she won't let the delivery person in to use the bathroom, kind of like us. If I leave at 2 o'clock really fast, it's because I found out on the way in that information you guys just got. She wouldn't let the guy in to go pee, and so he walked around the side of the building and peed against the building. And then when the delivery guy hops back in the van to drive away, Margaret pulls out a gun and shoots at the van, through the van, doesn't hit the person, is charged with discharge of a firearm into an occupied vehicle, which is a felony that carries up to 10 years. All right. That is one type of case over here who said permanent resident or applying to be a permanent resident. Margaret's a permanent resident, gets into this kind of trouble. Hypothetical number two. So this is a totally different type of scenario. Mario is here with no status, so totally undocumented. My clients refer to themselves as illegal or some other kind of racist terms, even to themselves, but no status. The employer is getting audited. When you started your public defender job, you had to fill out an I-9 and mark on there, I'm a U.S. citizen or I'm a permanent resident. Well, people have been known to buy fake documents, get jobs that way, and when the company gets audited, the companies always say, oh, we had no idea this was going on. And then the person gets arrested. So Mario is discovered to have given a fake name and a social security number, charged with forgery. Misdemeanor carries a maximum of 3 years. Also a real case, still a pending client of mine, not named Mario. So that's two different scenarios. One is permanent resident charged with something. Scenario number two is no status at all. Okay, so just keep those in mind. I'm now going to go through kind of some of the details of immigration law so that you know kind of what we're talking about. In part, I just like lawyers to be informed when speaking of things like this. Immigration is such a widely discussed topic politically, and I just always cringe when a lawyer calls me and says, "Hey, Charles, I got this guy that I've known for years, and I want to help him become a citizen." And just the phrasing of that question tells me the person knows nothing, is really ignorant. And I want you to at least not be that ignorant by the time we're done, okay? And also to be able to identify cases that are going to be problematic for you in your profession. So one type of status is just the person who has no status, not here legally at all. Many of my clients from Mexico, Guatemala, Honduras, El Salvador, they make it up to northern Mexico, they pay a coyote, they cross illegally. It's just one way people get here from Mexico because of, we have a long, porous border. Another way that somebody gets here is, they have a tourist visa. And so lots and lots of people come on a tourist visa and then they just never leave when they're supposed to. I've represented lots and lots of undocumented Canadians because Canadians don't have to get a visa. You literally just drive up to the border. When you go through a border, like at the border or on the airplane, you're essentially being issued a visa in that interaction. And unless they have an adverse immigration history or criminal history, Canadians are just kind of let in. But if they stay longer than their period of admission, which is normally 6 months, they're just as illegal as somebody who entered from Mexico with no visa. So one type of status is the person not here lawfully at all. And so those of you who have DUIs or CDVs or whatever with totally undocumented people, that is it creates one set of issues for that person, which we'll discuss. Other ways to lawfully be here are tourists. Unlikely that a tourist who has the money to get a visa and get here would be appointed a public defender, but that is a category. Europeans, Canadians literally can just kind of get on a plane and come here, and we essentially just let them in, with some exceptions. Most people from non-European countries, including Australia, New Zealand, some other places, if you're from Peru, you have to go to the U.S. Embassy and get one of these things. And this is actually a visa, that lets you come into the U.S. When I hear political discussion of, why don't people just come in, just follow the law, just obey the law and come in, legally, the truth is, super easy for Canadians and Europeans. You get on a plane, you come here. If you're from Mexico and if you go to the U.S. Embassy to apply for a tourist visa, well, number one, the last time I checked, like if you got on the computer right now to make an appointment with the U.S. Embassy or U.S. Consulate in Mexico, the first opportunity you have to go ask for a visa is sometime in the spring of 2024. They're so backlogged, you can't even get in to ask for a visa for a year and a half. And for countries that are more economically disadvantaged than ours, or at least are perceived that way, essentially only people with high education, high income will be even given a visa. They're just not. They're just going to be denied. If you are middle or lower income, Mexico, Guatemala, Honduras, they simply won't issue you a tourist visa. And it's true of a lot of African countries, South American countries, some Asian countries. It's true of a lot of places around the world. Where are we? Students, temporary. There are some temporary work visas. People that will come work for a few months and leave. Asylees, so like all the people kind of flooding the border in the last few years from Honduras and Venezuela and other countries, a lot of them are seeking asylum. And the U.S. is a part of treaties, and we have in the Immigration and Nationality Act laws governing when somebody comes to our country and says, hey, I'm going to be persecuted or killed if I go home, we have processes for processing them. And right now we're just overwhelmed with numbers and have inadequate resources to process all of those. But that is another category of people. Our court in Charlotte, historically over the last 15 years, denies between 90 and 98% of asylum cases. And so it's not a good, I haven't taken an asylum case in over 10 years. It's not worth it to me. It's extremely, extremely difficult to win and a ton of work to do them well. DACA, has anybody heard of DACA or DACA? Okay, so that's super popular right now. I have hundreds of DACA clients. It is something that the Obama administration really did just invent, kind of out of whole cloth. There is a statutory basis for it. It makes sense. There is this category called deferred action, and some brilliant lawyer in the Obama administration said, essentially, if you are a person who was under 16 in 2012, entered before 2007, went to high school, don't have a criminal history, that category of cases, they are here temporarily on two-year work cards, basically. And so every 2 years, I renew these cases with people. The biggest thing for DACA is kids with DACA are basically, they grew up here. They're just like my kids. And the biggest, anybody want to guess what the number one offense that is problematic for them?
Drinking?
Uh-huh. Yeah. One single DUI makes a kid with DACA ineligible to renew DACA. It's a huge deal. And so, you know, if you have a DACA client, again, unlikely in that context, but if you have a DACA client, they got to take a plea to something else if there's anything you can do. TPS is another category that we have for now Venezuelans, Haiti, Honduras, Honduras, a number of countries. There's these humanitarian parole, like what happened with Afghanistan in the summer of 2021, Ukraine this year. The government basically said if you fit certain parameters, you're from this certain country, we'll let you be paroled in for humanitarian reasons for a little bit. That's just another kind of weird temporary status. U visas. This is a huge and critically important category. A U visa is a visa for a victim of a violent crime. I have hundreds of these. I signed green card applications with 2 people this morning. The U visa is the person was a victim of a violent crime. The local police certify that fact, and it has to be the chief or the sheriff or somebody that the sheriff or chief has designated. The person has to have suffered substantial physical or emotional harm, and then some other things, but that's the crux of it. The idea behind a U visa is we don't want people who are victims of violent crimes to be afraid to go to the police, right? Afraid to report. And so most of these clients for me are domestic violence, armed robbery, some combination of armed robbery, aggravated assault, kidnapping. It has to be something on that level to be eligible. And it gets a person a visa for a work permit for 4 years, and after 3 years they're eligible for a green card. And it forgives all kinds of horrible stuff by that person themselves, by the applicant. And so it's like a get out of jail free, it's a magic visa, but something pretty bad had to happen to you. Now, if I were in your shoes, I don't think, or at least I certainly hope, there's not a lot of abuse of that visa going on where somebody's, alleging something in the hopes of getting a U visa. But if I were a defense attorney and if it struck me as that was something that might have been going on, I think it's a fair line of inquiry. I don't think you're going to get very far because the federal law surrounding U visas the privacy law is extremely strict, and I don't know how you would get those records, but I don't know. It's something that as a defense attorney, you should at least be aware that that visa is out there. As an immigration attorney, I can just help. I've helped tons and tons of people with that. Okay, this is what a work card looks like. It says work authorization. And with that and a social security card, somebody can go get driver's license, job. In South Carolina, one of the reasons that with almost every client that I have, almost everybody, I have some sort of traffic offense history, right? Driving without a license, driving with a suspended license, driving without insurance. Because South Carolina in 2012 passed a law that said if you don't have proof of immigration status. DMV actually has to run your card and your social security number through a system with immigration to verify that you're here lawfully before they will issue you a driver's license. And so if you have, if you're undocumented, have no status at all, you can't get a driver's license. It's like super exciting. In fact, when I go back to my office, I'm going to be giving a guy his work card for the first time, and I'm like, yes, I don't have to drive without him. I can go apply for a driver's license now. But and also get a job and not have to do roofing and landscaping and stuff. Okay, so that's all the temporary visas. Other types of status are lawful permanent resident. So you're a person who's in the process of applying. This is what historically we've called a green card, right? And they are actually green again. And so what that means is the person retains their foreign citizenship. So a Canadian or a Ghanaian or a French person who becomes a lawful permanent resident retains their home country's citizenship and passport, but they get a card that says you're allowed to live here permanently. This is your life. And in fact, you have to live here permanently once you get that card. It lets them travel, but it is not citizenship. So a person who's a lawful permanent resident for 5 years can apply to be a citizen, and a citizen, a person with a certificate of citizenship, is no different than me. I'm a citizen because I was born in California. I happen to have been born in California. It made me a U.S. citizen. A person who is a permanent resident for 5 years and then applies for citizenship and is granted can become a citizen. And that's why when the lawyer calls me and says, hey, I want to help my undocumented buddy become a citizen, I'm like, you don't even know anything, right? Because you can't just say, hey, my friend is a lawyer. Let me be a U.S. citizen and have a U.S. passport. No, there's all this other stuff that comes way before that. Certain U.S. citizens born abroad, also have citizenship. Sorry, that's a green card. So with citizenship, when a lawyer calls me with a criminal case, there are times when a foreign-born citizen with permanent resident status, if their parents became citizens while the child was under 18, there are circumstances in which a child actually is a U.S. citizen and they don't know it. So that's often one of my first lines of inquiry too, is find out about the parent's immigration status. Years and years ago, I had a client, I think he was Vietnamese, who had serious drug charges from when he was a teenager, like trafficking and all kinds of bad stuff. And it was just a lifelong problem for him. And I spent a little time looking into it, and I'm like, you're a citizen. And so we went through the process to get his passport, and then a U.S. citizen can't be deported, essentially. And so, everything was fixed in terms of his, worrying about being deported. I just have a list here, and I think in my handout I give a list of the different agencies that you're going to hear and run across. Mostly, people with immigration holds are going to have ICE that is in the jail or has gone to the jail to visit people. There's an ICE investigations unit too that's, they're investigating things like alien smuggling, immigration fraud, maybe drug trafficking too involving aliens. At the bottom of that list is EOIR, that's the immigration court. They're a part of the Department of Justice. So when I go to immigration court, you can always tell who's new in immigration court too, because real lawyers stand and we sit. And it's literally tables sort of like this. The government's over there and I'm over here with my client sitting. But when I try a case, it's me and my client over here. Over here is the United States Department of Homeland Security. And on the bench, my judge is the Attorney General of the United States, right? So it's me against two federal agencies. We don't really have independent arbiters. It's both the judge and opposing counsel are a part of the executive branch. Immigration judges are not independent judges. They work for the Attorney General. All right. If you find out that somebody has an immigration hold and you want to talk to immigration about it, you got to have one of these signed. This is a Form G28. And so just in case that ever comes up, like literally before the ICE agents will talk to you about, are they going to let them out, are they going to give them a bond or anything like that, they should require this form. So you may want to just look up Form G28 at uscis.gov. I sign dozens of those a week. All right, so This is not our beginning hypotheticals. This is just a couple to bring us all up to speed. John is a lawful permanent resident, arrested for simple possession. What's his status? What's his immigration status? Documented. What status specifically does he have? This is not a trick question. Yeah, permanent resident. So he is a lawful permanent resident. What agencies might you interact with? That was a dumb question, never mind. What are the possible consequences of his conviction? So when you have a permanent resident client, what you are trying to do is prevent their deportation, basically, right? They already have that status, and you just want to keep it from, them being deported. As opposed to a totally undocumented person, well, they can already be deported, right? If you are here without permission and ICE finds you, you may have certain defenses, but essentially, you can already be deported. And so you're trying to preserve their opportunity or their eligibility to maybe apply for something or return in the future, right? And so it's different. The consequences are more serious for the permanent resident, I think, certainly, because they already have that status. Now, we don't have time for that. We don't have time for Mary. Well, Mary, this is another question. Mary is a citizen, or a student at USC, not a citizen. She's in the U.S. on a student visa, and she falls in love and gets married to a U.S. citizen. This is sort of like my bread and butter case, is you're here, you fall in love, you get married, you come see me, and I will represent you in your application for your green card. But she has a DUI, and so that's your current situation. And I'll go ahead and, because I'm going to run out of time, I'll go ahead and answer, or at least address that situation right now. Somebody who's currently in the process of applying for a status, there is a list of offenses that just categorically make you ineligible. It's at INA section 212. And so essentially,
Can you repeat what that was?
oh, it's in the handouts. It's section 212 of the Immigration and Nationality Act. The main one that get most people in trouble is crimes of moral turpitude. And so if you're convicted of a crime of moral turpitude for which 6 months or more, with a sentence of 6 months or more, that's a problem for that kind of person. But a whole other category for people, especially when they're in process, is the government just always has this broad discretion. Should the government act favorably in your case? And if you have a bunch of DUIs pending while you're doing this, they could deny for discretionary reasons, and even if the conviction's thrown out, or even if if there's no conviction, they always can deny for discretionary reasons. We can't really control that, right? We can't control what the client did before they came to us. We can't control how the government might exercise their discretion, but the more you can do to what you always try to do, lower the level of offense that they're ultimately convicted of. So a simple DUI wouldn't make this person ineligible, but it certainly can affect the case. I got to skip all that. Okay, why does all this matter? Padilla, at this point, everybody is familiar with Padilla, right? Is everybody familiar with Padilla? Do you learn this in law school now? You didn't learn this in law school in 1989, I can tell you. The basics of Padilla is this guy, a lawful permanent resident, was driving a tractor trailer through Kentucky loaded with marijuana. I mean, it was apparently just had lots and lots of marijuana. And his lawyer, in determining whether he should plead guilty, said to the guy, "You've been here forever, you don't have anything to worry about." And the Supreme Court said, no, when the immigration law is not succinct and straightforward, a criminal defense attorney need do no more than advise a non-citizen client that pending criminal charges may carry a risk of adverse immigration consequences. But when the deportation consequence is truly clear, as was in this case, the duty to give correct advice is equally clear. That to me is just mind-boggling, that you have to give correct immigration law advice. I've been doing this for 18 years, and anytime I get a call on criminal consequences, I grab the INA and I look it up and I make sure that it's right. And I know where to look, right? It's what I do every day. That is really, really quite a burden on you. And so in this case, because trafficking clearly makes a person deportable, his attorney said you don't have anything to worry about it. The court said no. And here's the legal framework for that. When you're entering a plea, it has to be knowing and voluntary, right? And so if you're going to enter a plea, your client deserves to know, like, what are the offenses? What's the offense that I'm pleading guilty to? What is the proposed or the likely sentence, the possible sentence? And you just have to include the immigration consequences as a part of that. So you say, well, the plea offer is this, and it carries this amount of time, and you will go back to El Salvador, right? You will be deported. Or this is the type of offense that the government absolutely can deport you for. And if the client deserves to know that, and you have a legal, ethical obligation as their lawyer to inform them of that when discussing the plea. That's the crux of Padilla. All right. I'm rushing, and so I apologize, but I'm going to rush. The first category, and especially for public defenders, that you've got to avoid are what's called aggravated felonies. For those of you guys you don't have your computers out. Oh, some of you do. Oh, I mean, for those of you who are nerds, 8 U.S.C. 1101, Section A43 lists the aggravated felonies. Okay, and here's how this works. Because of our crazy federal system, the Immigration and Nationality Act is passed by Congress, right? And so they can't write an immigration code that contemplates every criminal statute in South Carolina and in North Carolina and in the other 48 states, right? So the immigration law is written with broad terms, and then there's just all this case law to determine, well, we look at South Carolina's statute, and is it really that? But some of the things are pretty clear. So aggravated felony means murder, rape, or sexual abuse of a minor. So those of you who said CSC with a minor, anybody convicted of CSC with a minor is an aggravated felon, and somebody, well, okay, maybe not, but almost certainly an aggravated felon. And aggravated felons lose all of their defenses. So with certain types of cases, a permanent resident who's convicted, I've represented people, permanent residents being deported for crimes. But an aggravated felon, if I show up, the judge says, you're not eligible for anything. I wouldn't even take that case because I know I'm not eligible for anything. Aggravated felons, not eligible for anything, and almost certainly can never come back to the U.S., lawfully anyway, after being deported. So this is really what you want to avoid, right? Trafficking, drugs are bad, right? Trafficking, yeah, it's an aggravated felony. Other ones that come up, I actually had a public defender call me last week from one of these classes from the past, who called with this question: a theft or burglary offense for which the term of imprisonment is at least a year. So and so this person had a young man charged with burglary, and an aggravated felony is a burglary offense for which the term of imprisonment is at least a year. And so what I talked with her about was his term of imprisonment has to be under a year, right? So the definition is burglary, term of imprisonment of a year. Get the term of imprisonment for under a year, and at least it's not an aggravated felony. You can't promise the client that he's never going to be deported, but at least it's not an aggravated felony. Now here's the catch with term of imprisonment under immigration law. It includes suspended sentences. Right? So you get it? And so sentenced to 5 years suspended upon completion of probation or whatever. It was Charleston, has a mental health court. That was new to me. And they wanted to do that. And I'm like, oh, that's great. But if it's 5 years suspended upon completion of mental health court or whatever, it's an aggravated felony. It doesn't matter if the person never serves a day in jail. Does that make sense? And so a lot of times with defense attorneys, that's the conversation, is how can we finagle this so that at least you can keep it out of an aggravated felony? I've had people like serve a straight 5 months before, right? Just, it satisfied the solicitor, serve actual time, and it's not an aggravated felony. Here's a great one. A crime of violence for which the term of imprisonment is at least a year. So the same deal. I have won a couple of cases on that because of the not the vagueness, but the actual definition of a crime of violence. I've won 2 different cases at the Board of Immigration Appeals, convincing them that criminal domestic violence in South Carolina is not domestic violence. I'm proud of those in a weird way. But it gets down to the statutory definition that in South Carolina, domestic violence can include this and this and this, and it can include acts that under federal case law are not violent acts, right? And so there's other things that we can do sometimes, but mostly when I'm talking to defense attorneys, it's like, how can we finagle your plea agreement to keep it out of one of the worst categories? Okay. Crime of violence, theft and burglary. Okay, so here's the consequences. A person's deportable, ineligible almost for anything ever. And then that person who leaves and tries to come back in illegally, they're in a lot of trouble, right? So just all kinds of other federal criminal charges, and they're just out of luck forever on immigration too. Other major categories that come up often is this general crime of moral turpitude category, which is not really defined, and there's just tons of federal case law on what's a crime of moral turpitude. If they're under 18, there's some exceptions, and the other exception is, so this is a situation where the maximum penalty possible did not exceed imprisonment for a year, right? So as opposed to what the person actually gets, it's what's in the statute for what is the maximum possible. And so sometimes we can figure out a crime that's maybe a crime of moral turpitude, but that doesn't carry a year. Sometimes that's what we're working for. I'm going to skip all of this. Drug crimes, the only thing that years and years ago, I represented a guy in immigration court who'd been a permanent resident for like 15 years and had a 10-year-old simple possession of marijuana. That was it. And somehow ICE found out about him, and it was during an administration when they wanted to be tough on drug crimes. And so they tried to deport this guy for one simple possession from years ago. And fortunately, it was like my only real win in immigration court, or one of my very few. It was one of those great sentencing sheets where the judge had just written simple possession. That's it, simple possession. 30 days or fine, whatever. And I went, the government tried to use that as the charging document to prove he'd been convicted. And I'm like, Your Honor, I moved to terminate the court case because they haven't proved anything. They haven't proved that this is simple possession of anything. Of what? And the judge agreed with me because I was clearly right. But simple possession of marijuana can still get you deported. And now, even though it's legal in so many states, but it can get you deported from South Carolina, well, with a simple possession charge here, or conviction here. Unless it's under 30 grams, that's it, for personal use, one time. All right, so back to our hypotheticals from the beginning. So Margaret, who's a permanent resident, right, shoots into the back of the truck, charged with discharge of a firearm into an occupied vehicle, a felony. My concern is certainly that it's a violent crime, right? That it's an aggravated felony. And this person had been a client of mine. I got their green card, and then they did this. But fortunately, they got a really great privately retained lawyer. But, he's really great. And he called me and said, Charles, what can we do with this? And I'm like, not much. And of all people, the solicitor came up with an idea. And aggravated breach of peace. Aggravated breach of peace. It's not when you look at the common law definition of aggravated breach of peace, it gives me an argument, right? It gives me an argument that it's not a crime of violence. And that's what we're looking for if you're trying to do the best you can for your client. This guy might still be deported, or he might at least be placed in deportation proceedings, but this gives him a chance to do something, other than just sort of an automatic, ring him up deportation. Mario, who's here with no status, gets in trouble with his I-9 using fake documents, charged with forgery. Again, forgery is a misdemeanor with a maximum possible sentence, but even with that, forgery and an aggravated felony includes an offense related to bribery, counterfeiting, forgery, in which the term of imprisonment is at least a year. So it carries 3. If this person is convicted or, suspended sentence of more than a year, it's an aggravated felony. And so, you got to try to find something other than forgery. And for this person, oh man, I can't remember what they got. I don't remember. It was some sort of misdemeanor, false alteration of documents. I can't remember. But you just got to sit and look through the code and just see what might the solicitor accept, what might everybody be able to get on board with that isn't just sort of a, get them deported. All right, here's my just general recommendations. And I don't really have time to explain all this. PTI is fabulous, right? If it's a true solicitor's pretrial intervention where the person never goes and enters any kind of guilty plea, for our purposes, it's a dismissal and it works just fine. And so PTI, I love PTI. Any other kind of the conditional discharge, anything where you have to first enter a plea, even if it can later be expunged or dismissed, it's the entering of the plea that locks it down for immigration purposes. So PTI is great, conditional discharge isn't. Any drug conviction is bad, any violent crime is bad. Pay attention to the aggravated felonies. And then here's my bottom line always for this presentation. If you don't remember anything else, here are the 2 things I want you to remember. Number 1 is my cell phone number. And I think I put it in my handouts too, but my cell phone is 803-238-5919. 803-238-5919. I always answer calls from public defenders. So if you ever have one of these questions and need to know, call me.
Would you prefer us to give you like a heads up, like a text or something first? I'm not sure.
No, just always leave a message, because if I don't recognize the number, and I don't answer it, because too many people have my phone number. But leave me a voicemail, which nobody, like young people don't know how to, you people don't know how to do, right? Leave me a voicemail or text me that I know, hey, I'm a public defender, and then I'll be sure to answer it. Yes, that's a good idea. But the other thing is, always ask. I don't know really what your intake process is, but to me, you always have to ask, where were you born, right? If you don't know where your client was born, you don't even know that this is a potential problem. And so obviously for me, my intake form, anybody that walks in my office, I know their date of birth and where they were born and all that. And then for you, if they were born anywhere other than the US, you need to follow up in some way, right? If they were born in a different country, well, maybe they were born to a military member and they have a passport. Okay, great. You're a US, you know you have a US passport, great. But if they don't have immigration documentation, or if they say, yeah, I have a green card, you're not even going to know that if you don't ask the question. And I can just tell you, I have tons of clients from lots of different countries around the world that if you just walked up to them and talked to them, you'd be like, you have no way to, there's no way to know where somebody's born without asking them. And so if you have a foreign-born client and any kind of criminal issue, at least you know to follow up, right? Try to avoid the aggravated felonies, and then people in process, you're trying to avoid a whole lot more than that. But if you call me, I'm glad to help you. Immigration holds, let me just touch on that real quick. An immigration hold simply means that the feds are asking the jail to hold that person for 48 hours. The jail doesn't have to, but they do. And there is a form that they are supposed to put in the file, and they're supposed to give that actual detainer. It's a form. They're supposed to give the client a copy of it. It's supposed to be in their file. And so if they say there's an immigration hold, it's not a hold without that piece of paper. You might have to go to some extraordinary measures to try to get them out of jail, but it's not a hold without that. And if it is a hold, usually that's when an immigration lawyer needs to get involved to see what's going to happen on the immigration side. All right, any questions really quick before we go, or I go? Yeah.
All right, so I know you touched on this earlier about the ICE form.
About what?
The ICE form G28.
Yep.
Other than that, like, is there really much I can do about an ICE hold?
Is there much you can do about an ICE hold? Well, once the bond is paid and if 48 hours have lapsed, you say, let my client out of jail. They don't have any authority. And if they are going to detain the client, there are particular facilities that cooperate with the feds, like Lexington County. And so they might move them to Lexington or might move them to the middle of nowhere in Georgia.
I have one in Flagstaff, Georgia right now.
Yeah. 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 Right. Yeah. Yes. They're going to move them. They're going to move them to South Georgia. Yep. Or to Atlanta. Yeah.
And this may be like a weird specific subsection, but on the U visas, you
Yes.
said there are all sorts of things that can overcome.
Uh-huh.
Is pending criminal charges?
Uh-huh. Yeah. I have. Yeah. There's a limit. Like, I'm not sure that they would approve a U visa for a drug trafficker. I have lots of people with CDVs and DUIs and simple possessions who've gotten U visas. Yep. So if a person is also a victim of a crime or has previously been a victim of a crime, yeah. If you come see me, I'll tell you how to find that person. Okay. Okay. Thank you. Thanks, Lawrence.